Good morning. I'm Heather Gordon from UNH Innovation, and I'm happy to be here to introduce the last session of our 5-part webinar series, Turning Your Innovation into a Business. Today's webinar is hosted by the New Hampshire SBDC and UNH Innovation. UNH Innovation is leading a U.S. small business administration initiative called Foster to increase proposals for SBIR, which are Small Business Innovation Research, and STTR, Small Business Technology Transfer Grants in the state of New Hampshire. Foster offers training on the SBIR and STTR submission process, as well as guidance and one-on-one proposal preparation support for qualified companies. So I'm going to turn it over now to Jason to talk about SBDC and introduce our guest speaker today.
Thank you, Heather. Hi, as you said, my name is Jason Cannon. I'm with the Small Business Development Center, also known as SBDC. The SBDC is the leading resource for business advising and education in New Hampshire. Our certified business advisors provide confidential, highly individualized advising across the state. We're so glad to be partnering with UNH Foster and the U.S. Patent and Trademark Office on these Turning Your Innovation into a Business series, which leads me to our amazing presenter this morning. We're lucky to be joined today by Alford Kindred, Supervisory Patent Examiner at the U.S. Patent and Trademark Office. And I'll hand it over to Alford. Thank you.
Thank you, Jason, and thank you, Heather. I appreciate you guys having me here today. Let me put the slides so to make sure you guys can see the slides. Are we good? Can you guys see them?
Yes.
Okay, awesome, good deal. My name is Alford Kindred. I am a supervisory patent examiner, but just to give you a bit of background or my bio, graduated high school, went in the Marine Corps. Went in the Marine Corps for 6 years, then I got out and got my engineering degree and worked for the patent office. I've been here at the patent office for over 30 years. And during that time, I had the opportunity to go to different places. And at one point I was at Detroit when they first had the satellite office there. And that's when I really got into the outreach type of thing. I did a little bit back at headquarters, but I really got into what is it that we want to tell people about innovation, about patents, and the importance that it is, the importance that it have on our economy. I'm back now at headquarters, and I'm getting an opportunity to do it again. So it's really my pleasure to do this. And I want to thank Elizabeth Doherty. She's heading this whole thing, and she's doing an excellent job. As a matter of fact, I got started by watching Elizabeth Doherty, who's the director, doing a presentation, and she did a fantastic job. And I said from that point, that is what I want to do. So to begin, I like to start off with the story first. And I think it's very important that I start off with the story first, because it actually puts some type of real life, if you will, a scenario on what we're going to talk about today. At the Detroit office, I was the general manager there at that point. And what we did was we had a patents basics, and we talk about searching on a weekly basis, on a bi-weekly basis. So this one particular time, we brought people in, and we were talking about just patents, you know, about we had entrepreneurs, innovators, and small business owners that came. They wanted to know how to protect their intellectual property. And before we started, this one individual stood up and said, I want to learn about, you know, how to protect my intellectual property. I have an event that I have to go to the next day. And I want to have some way, well, not the next day, I'm sorry, a week from that day. And she said, I want to disclose this invention, but I don't want anybody to steal it. So what could I do? And of course, that's the number one problem that most people have. They have that invention. You have that thing that you think that makes something better, but you don't want to disclose it because you don't have the money or the resources to hire an attorney to get it protected right away. So luckily at that time, on that that class, we was talking about intellectual property basics, where we talked about the provisional and the non-provisional. And what's key here is, remember, that person had to have, they wanted to show their invention that following week. And so it's kind of like people think that it's impossible to get some type of protection. But we talked about the provisional application, and that's when her eyes perked up. It's actually a couple. And we talked about how if you have to show your invention within a week, you have this burning desire to show your invention, but you don't have the money to hire your attorney at the time. And we talked about the provisional application, and we talked about how she had to have just a simple way of describing her invention. She has to be able to describe it, how to use and make that particular invention. You don't have to have all of the legalese language in it and things of that nature. And she really loved that. But I told her the first thing she needs to do is do a search just to make sure that it's not out there before you invest anything in there. So guess what, folks? Luckily, at the office there, we had a room where we were offering free searching help. So that very day, she had an opportunity to go and get some help from the Patent and Trademark Office on just searching for free. And she did a search. She searched for like 4 or 5 hours, then she came back. So to make a long story short, she ended up actually deciding to file for a provisional application within the next couple of days, which means that she had to file for it and she had to get some information back from the patent office so the patent office can know that it's her. And she filed for it with just that language of how to describe and use it to get a provisional application. And that's what she did. So with that provisional application, that following week, since she got confirmation from the patent office after she filed for it, and it was $70 because she used micro entity, she qualified for that. And most people qualify for that. She filed it and she got it. And so what she was able to do was that following week where she had to display her invention, it was actually a week and a half after that, she displayed her invention, she did. But she actually was able to put that patent pending thing on her invention to let people know that, hey, I may not have a patent, but I'm letting you know that I'm going to protect my intellectual property, and this is mine, and this is the date that I have it. So that's the importance of it, and that should be for everyone to understand. And these slides that we're going to go through, we're going to talk about intellectual property, but I want you to keep that in mind because that is something that people can do the very next day. It's something that you can start off with. All right. So now let's begin. We're going to talk about protecting your IP. In this particular section, we're going to talk about patenting the apps software, which is something fairly new. The discussion of the topic would be IP is a business strategy. What is intellectual property? Filing the patent applications and best practices for filing US patent applications for apps and software, but also we're going to add in provisional application. And last but not least, we're going to talk about these free resources that USPTO offers, which I think you all should take advantage of. IP-intensive industries are a critical, important component of the United States economy. Absolutely. 45 million jobs are based in the IP industry. It comprises of 38% of the gross domestic product, which is huge. And also people who work in this industry, in the IP intensive industry, they make 40% higher pay. IP is a strategy, a business strategy. And why do people use IP? First of all, you IP, which is intellectual property, you use your intellect or what you create or your ideas to attract people to invest in your creativity, to invest into what you think that's novel or your ideas that you come up with. You also can use it, say for instance, if you do get in business, you can use, once you protect your IP, you can use it to leverage with other businesses and also to merge with other people who have similar ideas or in similar areas. And also it's a right. And it's is a valuable company asset, but you have intellectual property. That means no one could come to you if you have a company and you have assets in your company and you actually conduct the business. You don't want people to you don't want anyone to send you something to say, oh, by the way, cease and desist. I own the rights to that. So it's very valuable and it is global. Now, it's a caveat to that about it being global, because once you get a patent in the United States, it's for the United States, but there are other means for filing for a patent to make it for other different countries as well. Why invention matters, what it means to you. For one thing, it promotes innovation and helps safeguard your invention. And what we mean by promoting innovation is it's kind of selfish on the U.S. part because we want you to we're going to give you protection, but we want you to give us your invention so people can build off of it. That way to promote innovation for the whole country itself. So we need your ideas so people can build off of your ideas as well to even make it better. It helps companies grow. And not only does it benefit the community, but once you have a product, say for instance, you have a product, but you don't want to put that product out there because you think that somebody's going to steal it or you don't have the money to get it protected. So how it benefits the community, if you're able to get some type of protection and you're able to get your product on the market faster, it benefits the whole community because your product can be out there and it'll be available for those people to purchase. And just like anything else, anything dealing with your mind, your creativity, it promotes personal growth and development. Because once you start giving your ideas and things that you create in your business and stuff, if you give that a lot of attention, it not only helps your personal growth, but it helps your confidence. And also it helps promote you to keep continuing to grow and continue to promote and develop. What is intellectual property? Think about this. Think of intellectual property as a house. You see that picture on your left-hand side is a house. And on that house, and in that house, in that picture, you see that fence surrounding the house. And that's probably the property line, the boundaries of that property. Intellectual property is the same thing, but it's your mind, it's your creative thoughts. There's a limit to what your creativity is or what your ideas is. So your creative thoughts and the boundaries around your thoughts or the limits of your thoughts is the property part of it. So it's your intellect and the boundaries around your intellect on how far they go. And it is measurable. The types of intellectual property. Of course, we talked about patents, and we're going to go in more detail with patents. You got patents, which is new and inventive ideas. You got trademarks. And normally, if you have a patent, you probably will have a trademark as well because you need to identify it. And trademark identifies the origin of the good. So you see that sign, if you know something, if you see a check mark or something, you know that's Nike. If you see a sign and you know exactly what it is, that's trademarks. Copyright is a little different. It's your creative juices. If you create a play, a poem, or you can write a letter to somebody, you can. That's automatic. Believe it or not, folks, that's automatically copyrighted. However, if you wanted to be able to protect against somebody, then you had to go get it federally registered. But a copyright is just anything that's stored. And if you want to think of it in general, if you write something down and you put a period, and that's the end of that, that's copyrighted. That's copyrighted, and that's what you copyright. Trade secret is exactly what it means. It's a trade, but it's a secret. We're not telling you what it is, like Colonel Sanders' secret recipe. But what most people don't know is Google has a trade secret as well. And they were smart the way that they did it. When Google first started out, they had an algorithm like Yahoo and some of the other search companies. And what some of them did was they patented their algorithm. Google said, not going to do it. I wanted, because if you patent it, you get 20 years. Google was probably thinking, no, I want more than 20 years. This is an awesome algorithm. I want to get protection forever, or as long as I could. So they made, instead of it, they could have got a patent for it, or they could apply for a patent for it, but they decided to keep it a trade secret. They didn't tell anybody what that algorithm was. And to this day, no one knows what it is. So they still have that trade secret. So that way, that's an instance where trade secret really paid out for a company. So that's what a trade secret is. You got patents, trademark, copyright, and trade secrets. An IP portfolio. Now we're coming into the app. That means your portfolio, and this is an app example. For patents, most people know when you get a patent for something that you do a series of steps or an invention. And with utility, which most patents are utility patents. You can get design patent, but most people get utility patent because it's something that is an action or a series of steps. And in order to get a patent as part of your portfolio, it has to be new, novel, and non-obvious. And if you go to any patent, it has to be new, first of all. It has to be novel and non-obvious. And we're going to go into it later on, but non-obvious just means that it just can't be an obvious deviation of what somebody else did. That's what the non-obvious part of it. All right. And that's what patents. With design is a little different. There's no series of steps in design patent. Design is something that's ornamental. It's something that doesn't move. It's just stationary, like the form of a car. And in the form of an app, instead of us having normal design where it's a picture of a car like that does a design. Now that picture can translate to your app, to your phone, to your phone. And if it's a picture up here, you get the same protection on it. So it'll be a picture on the phone or a design on your phone, and you can get a patent for that design on the phone. It's called a graphic user interface. So in other words, they just taking something that's manual and putting it in electronic form. And yes, you can get a patent for that. So you can be just as creative on your phone or your laptop or what have you, as you could just putting it on a piece of paper or just putting it out there. All right. Trademark, the same thing. Everybody knows you got the Nike swoosh and some of the other trademarks out there. But when it comes to an app, it's the same thing. It's something that's on a what they call a graphics user interface, which is something electronic that's being displayed electronically. So the trademark that you would see on a sign or something like that, now it's on you can have a trademark on your app, an app for something, and you can design an app with a trademark, and it's the same thing. You get the same type of protection for that app as you would for somebody having a trademark on a sign. So they're just bringing the same, they're just translating that over to now, since we're all digital now, to the digital side of it. All right. So again, with the trademark, is if it's on your graphics user interface, then you can get a patent for it. If it's unique and new. Copyright, the same thing, but with copyright, with the IP portfolio with the copyright, is a little different. The copyright is the code behind the manual, the code behind how to use something. It can be copywritten. So it's actually the code of the works that you have. And of course, trade secret, folks, same thing. It's a trade secret. So you won't know what it is. So as part of your portfolio, you keep that trade secret a secret. And guess what? There are things that you have to do to make sure you keep it secret. First of all, you can't just tell anybody, and you can't leave it open where somebody can steal it or come get it or see it. Getting started, plan early, develop the process. And as we talked about earlier, you're going to create your intellectual property strategy. How are you going to go about it? If you have money and you have means, yes, hire a good attorney. You can do it somebody to work yourself, but it's good to have a good attorney, especially if you're going to file a non-provisional application. Obtain help. And that's where the SBDC, the USPTO, and some of the other resources, you get help on how to start, on if you have questions, on what do you do next, or where do you can get resources and things of that nature. And most importantly, I think is most important, is the research, the prior art. It's look and see what's already out there. And believe it or not, when you look to see what's already out there, folks, people sometimes, and this is what I've seen over my almost 30 years at the patent office, sometimes when you're looking at the prior art and you're searching stuff out there that's similar to yours, you get other ideas. And sometimes you kind of manipulate yours a little bit. So keep that in mind. And carefully disclose your documents and disclosure. In other words, keep that, keep your stuff secret. Don't let everybody see what you have. Because if you have an invention, and say, for instance, you decide to have a yard sale, and in that yard sale, people come from the neighborhood, and you talk about your invention. Guess what? If you talk to and somebody hear you talk about that invention, you have from that day to a year to apply for a patent. That's very important, and a lot of people don't know that. Once you disclose it, whether it's a thesis paper, whether you're talking to a group of people, or you're a PTA, or whatever it is, once you disclose it, you have up to a year to apply for a patent or a provisional application. Now keep that in mind. To try to get, in order for you to be able to get a patent for that particular idea. So I want everybody to let that sink in, because most people don't know that, but you need to be aware of that. When you have that invention and you keep it to your heart, or you keep it in that box for a long period of time. So you have up until you once you disclose it. All right. Let's talk patents, folks. Patent is a right to exclude others from using and making your invention as a limited term. And I want to harken back to when we talked about that global thing about patents, when I tell you that there's a caveat to that. Here it is. It's territorial. Once you get a patent in the United States, it covers the United States. There's no such thing as a worldwide patent. So but there are means where you can go, where there are ways in which you can go to and file for patents in different countries. So that is available for you. All right. These are the types of patents. You have the utility patents, as we talked about. And remember, always attach provisional to utility, because that's the only type of patent you can file a provisional application for. So keep that in mind. Put a note by that. And utility patent is something useful, something that has a series of steps or an improvement on something. Design patents. Think about it. Remember what I indicated earlier, that is ornamental. It's stationary. It's the way something looks. It's the design of something. Last but not least is plant patents. Plant patents are, most people are not familiar with plant patents, but plant patents are any plant that can be reproduced asexually. An example of that is you take the seed for one plant and you slice it in half, and you take the seed from another plant and you slice it in half, and you put them together and you cultivate it and you grow it, and it becomes some type of color or flower. Those, you can get a patent on that. That means that's what asexual means. And it's really becoming something that a lot of people are getting into. And we're not going to talk about the other type of plants that's about to become legal, that type of thing, but any type of seed that you can split and you put it together and you can grow it and it comes up, you can apply for a patent for it. This is the autonomy of a patent, folks. So say, for instance, you go all the way through and you get that patent. This is what the front cover of a patent look like for you all. It'll have your name, the inventor's title, the filing date of it. It'll have the issue date when they issued it to you, and the abstract. And the abstract will be just a synopsis of your invention, so people will know what your invention is all about. And it would show the different prior art that was listed, and also the drawings. These are the hurdles for getting a patent. The biggest hurdles is to know, to be able to describe what your invention is as opposed to the prior art. But one of the biggest hurdles is, as I indicated earlier, is the fact that you have this, it's non-obvious, which means that you figure out a way of making something better, making something go faster, making something more appealing. Your invention, you're creating something, but it's just non-obvious. Anybody would have thought to add that piece. So those are the hurdles to make sure that your invention or what you're creating is just not some obvious deviation or some obvious way of putting something together. And the last but not least, and I apologize for the slides with this last part where you can't read it, but it says, does it have utilities? And what the part that's missing is saying is, does it function as intended? Which means, does it do what you say that it does, or that the way that you describe it? So that's the utility. It doesn't have describe it as you described it. What is prior art? Prior art is anything, folks, and I want everybody to be clear with that. Prior art is anything that has that talked about your invention or displayed your invention before you had it. It could be patent, it could be a essay, it could be a thesis paper, it could be in a publication, a journal, it could be in a symposium where you spoke about it, about that invention. That's considered prior art. And that's what the examiners would use against you to make sure that you are creating something new and novel, and that you talked about this a year and a half or 2 years ago. Now you're trying to get a patent on it. And remember what I said, once you disclose it, you only have 1 year to apply for a patent for it. So that's why it's very important for you all to understand prior art, and to understand when you're talking about your new inventions or you're talking about your creativity, when you put it out there in the public sphere, that you have 1 year to make sure that you apply for it within that time frame. Presenting your idea. And one of the things that I think this is a very good slide, because I had the opportunity to be one of the speakers at this big STEM conference where they had all of these kids from all around the Eastern, the East Coast, and they come with these inventions that they have to improve life, to improve the filtration of water, all of these things. And they have these cardboards and these inventions. And the reason why is you got to be careful about that, because that's their invention. And from day one, when they show that to everybody, trying to make sure that they get the best, their project is the best project, they have to make sure. And that's one of the things that I told them. I say, when you do have these things, because some of these things may be really good, excellent ideas, you need to file for some type of protection even before you bring that cardboard out with those figures and those flow charts and those gadgets up there. You need to file for some type of protection to let people know that at that date and time, you were the author of that invention, that you had that invention. So be careful about where you present your ideas and make sure that you protect it even before you disclose it with anybody else. And if you have the funds, yes, get appropriate counsel to talk to you about it. Applying for a patent. This is it, folks. This is where it all goes. If you have that new idea, and most of you, if you're small business owners, you're constantly coming up with new ideas of making things better. You have that new idea. See that next step where it says optional, provisional application? It is optional. But if you don't have the funds, or if you don't take advantage of some of the resources that the PTO and some of the other places offer you for help for getting you filing for a patent, and you need to get it out there or you want to start on it, the provisional isn't optional, but it's an excellent optional. So if you have the new idea and you have an attorney and you're ready, you want to file for a non-provisional application. If you have the funds for it, you have the backing, you have the means, absolutely file for the non-provisional application, because that turns into a patent. The provisional application, I want you to think of it like this. It's just a placeholder. The provisional application is saying, hey, I want to file for a patent, but I don't have the money, but I want to make sure you know that this is my idea. So provisional gives you that option. And the PTO is saying, okay, if you fit within this criteria, you pay $70 and you write how you use and make your invention. And we're going to hold this. We're going to hold it for a year, give you an opportunity to get your stuff together to decide whether or not you want to file for a non-provisional application. And that's why I said that this is a good option. All right. So now you got your new idea, provisional. If you don't have the funds for it, that'd be an excellent idea. If not, file for the non-provisional application. Make sure you have everything in there, all the legally language, and then that goes into a patent. And you get 20 years monopoly on that. And what's the difference between provisional and non-provisional? Let's go with the non-provisional first. With the non-provisional, it's examined by an application. And guess what, folks? Your invention, unless you say so, will be published 18 months from when you file. So the examiner is going to examine it, and then got 18 months, then it's going to be published. So people are going to see your invention. And yes, it can become a patent. On the other hand, if you file for a provisional application, no one sees it but you. The examiner is not examined. Guess what? It's not even published. And it gives you a year to get your stuff together, to get all your ducks lined up in a row, to dot your I's and cross your T's. It gives you that chance to vet it, to see, hey, maybe this invention is good. Let me go ahead and put it on Facebook. Let me put it on this. Let me see how well it's going to sell here. It gives you a whole year to see how well that product or whatever your invention is doing, to see if you want to eventually file for a non-provisional application. And just remember again, it's only for utility patents. Design and plant patent, it doesn't apply. And if this bullet says is a low-cost way of establishing an effective filing date, I would go even further. It's a low-cost way of protecting your idea for a year until you decide to get everything lined up in a row to file for a non-provisional application. Non-provisional patent application, as I indicated earlier, the filing requirements for examiner, you can write it in your own language. You don't even need drawings. You just have your information up there. And also, you can search it yourself, or you can get a search company to search it. But if you use some of the resources that we have, the USPTO and the SBDCs, whatever the resources that they have, so you can search it for yourself. So the only thing that you need to have for a non-provisional have that's essential or that's required is for you to be able to just write in everyday language how to use and make your invention. What do I need to disclose? Well, you need to disclose everything because this system is called a quid pro quo system. That's the United States patent system. It's a quid pro quo system. It means I give you something and you give me something. And in this instance, it's the United States. The United States is giving me the right to have a monopoly on my invention for 20 years. So that means I'm in charge of my invention. No one can use and sell my invention without my permission. So that's what I'm getting. So you ask, well, what is the United States getting out of it? The United States is getting a whole bunch out of it. The United States is getting a whole lot of things out of it. The United States is getting your innovation, which is worth more than money. It's getting your technology. And what are they doing with it? They're putting it out there for the United States to see. And why? They put it out there so other people can see your invention, what you have, and improve on it and move on it and change things and make it better, or either make something different from it. And that's how we stay ahead of the technological curve in the rest of the world. But we have to have people in the United States to put their having their inventions disclosed so other people can see it so they can build on it. So that's why we give you the monopoly for 20 years, but we want your invention so we can have other people experiment on it and make things better and put better products out on the market and help keeps us moving forward and competitive in the world. What do I need to disclose? And also, one of the things that I think and this goes for non-provisional, by the way, folks, because it's talking about the claims, is you have to make sure that the claims are clear and that the public will understand what your invention is, so they can actually understand how to use and make it, so they can make improvements on it or figure out ways of making it different. This is the prosecution. This is the prosecution phase, and this is the flow chart. You file for a patent application. The examiner look at your patent applications. Yeah, I'm rejected. I don't think I found prior art. It goes back to you. You can decide to amend it, change it. Then it goes back to the examiner again. Then the examiner will say, well, you know, your amendments, I disagree. Then we're going to reject it. And you have the ability to say, okay, well, examiner, I'm going to go to appeals because you rejected it twice. On the other hand, you send your application in. The examiner look at your application. He examines it, and you say, reject it, send it back to you. You make some changes next. Well, excellent, great job. We're going to give you a patent because now the amendments that you did to the claims in your application it can become a patent now. The third scenario, remember, you go to appeal. The second one, you get a patent. The third scenario is if they reject your your application, right? And you do nothing at all, over a certain period of time, it goes abandoned. So that's the flow, that's the roadmap in the flow chart of how the patent system works. The role of a patent examiner is, and that's what we do. We read and understand the examiner. We search and look for everywhere. We look for publications, everything, to see if you disclose or if that invention was created by someone else before your filing date. And we also hold interviews as well. And I suggest if you actually file for a patent, for you to hold an interview, because that's a way for you and the examiner can collaborate and actually understand your concept. And normally, if you are straightforward in the interview, or your attorneys are straightforward in the interview, the examiner can suggest ways of putting language in your claims that will actually reflect your invention, that will make it a lot easier to be allowed. So that's the role of the examiner, is to help. The role of the applicant is to make sure that you disclose everything completely. And also, if you know of prior art, say for instance, if you know of something that's similar to what you have, you are obligated by law to make sure that we give that you give that information to us. So you have to give that information to us. So if you know that some prior art is out there, please give it to us. And I think that'll help out. And instead of having the examiner find out that art later, that makes it worse. So you're obligated, if you know, just like I said, if you know what some prior art is out there, you're obligated to disclose it when you as an applicant. Okay, and you can the response, as I indicated earlier, when you go back and forth with the attorney, just make sure that you explain your position and make sure you have good faith changes or amendment that try to help move the case forward. Is your idea eligible for protection? And this is one of the things that as a matter of fact, it's one of the questions now that with OneonOne thing that's going on. You probably all are familiar with it, but The eligible for protection is a process eligible for protection. Manufacturing is eligible for protection. A machine is eligible for protection, and a composition of matter. All of those are things that are eligible for protection. And what is patentable? Products, physical things, manufacturing, composition of matter, as I indicated earlier, composition of matter. I'm sorry. Processes, means to an end, means of doing something, new ways of doing something, or improving the way something was done the old way. And look there right in the middle, folks. The novel, non-obvious, and utility. The novel must be new. Number two, it must not have been just an obvious change of something that already exists. And last but not least, utility. It must be useful. It must have some use for it. It must be able to be used as intended based on what you read, based on your description. All right. What is not patentable? Must be able to develop into a new, non-obvious, and useful machine, manufacture, process, composition of matter. What's more important for this one is it cannot be natural phenomenal, and it cannot be abstract. So natural phenomenal is just things that happens naturally. An abstract idea just can't be just some uncouth idea that doesn't have any structure to it. That's new and novel. So that's not patentable at all. And this is there, by the way, folks, this is the area that I worked in. I worked in several other areas as well, but this is the area that I worked in, and is applicable to the software apps. And that's why this is here, because we're talking about patenting software apps as well as patenting in general. Software and computer architecture, this is just an example of some of the things or some of the areas that will have software apps in it. Computer error control, AI, which is artificial intelligence, which is huge now. Database files, computer architecture, etc., and memory access control. So that's in that particular area, in the software area. All right, and this is an example. When you take a look at these claims, when you get a chance, let it marinate a little bit and just don't try to really understand it because it's a complicated claim. But this is an example of a software claim, and as you can see, it starts off with a method for synchronizing. So it talks about a method, and there's a series of steps. So that's just an example of a software claim. And the software design patent, and this is key. Say, for instance, if you do get that software, say you design something on your iPhone or your tablet or app, and you get a patent for it, it will look like this. It will be a software design patent claim. It will be something where it says, this is the patent that you would get. And it says this, just like the claim says, the ornamental design for a graphic user interface for a display screen. So remember, design patents are ornamental. So ornamental. So if you have something that's fixated on your screen of your laptop, of your iPhone, of your tablet, or what have you, it's the same thing as just having a picture of something. You get the same patent, but it's for an app instead of you having an actual picture of something or the design itself. Okay, and that's what the patent will look like if it gets granted. And if you want to know more about the one-on-one, what's eligible and not eligible, when we send you these slides, if you click on that link below, it gives you all types of example of abstract ideas of what can and what can't be patentable or patented. And it's very comprehensive. There's a lot of information out there, and it's an easy read as well, folks. And as you can see, you'll see the helpful tools. If you go to USPTO.gov, you'll see the different examples. And I encourage everybody, if you get an opportunity, the PTO.gov site is an awesome site. It's very comprehensive. It's an easy read. It has examples up there, and is a good way of familiarizing yourself with not just patents and trademark, but just intellectual property in general. And everybody, if you have a business and you have a sign on your business that have your name, or if you have some type of invention as a part of your invention, I suggest that you familiarize yourself with this, even if you do use an attorney to file for your applications. And these are the best practices. Describe the technical challenges in your field. In other words, you for your invention, make sure you describe how you came about that invention. What are the challenges that you had, and what is your solution to those challenges? All right. And these are the USPTO resources. Again, USPTO.gov, and you are going to have a copy of the slide, so you better go through and just check out what we have out there. They have a whole array of information out there and resources. And these are the different areas. We talked about resources. These are the different areas that we're located. And as you can see, Detroit was one of the areas that I was in for a while, almost 3 years, by the way. All right. Thank you on behalf of Elizabeth Doherty and the regional outreach area. And she is the director. And folks, I'm telling you, she's awesome. So are there any questions?
Thank you very much for your time, Alfred. And thank you everybody for attending and for participating. We hope to see you again on a future presentation.
Thank you, everybody. Stay safe out there.
Thank you all. Have a great day.
You too.